Let's talk about an update in the Kohberger case. A judge has declined to throw out key evidence in the case against Bryan Kohberger. Major ruling on Wednesday. Judge Steven Hippler denied the defense's request to exclude DNA and other genetic evidence from Kohberger's upcoming murder trial. The defense was looking to suppress that evidence, which was seen to directly link Kohberger to the crime scene. Yeah, it did. It's his DNA on that snap on the knife sheath. The judge ruled that Kohberger's rights were not violated by police behaved properly when they gathered that evidence. They used genealogy websites to do it. The judge also ruled against 3 other defense motions objecting to the way that warrants were issued. They wanted a lot of this evidence suppressed, including the cell phone data. Judge said, nope, let's let the jury decide. We'll continue to monitor developments in this case as they get ready for trial coming up later this year. Jacqueline Goodman, I don't know how up to speed you are on this, the defense filings in this case. They basically were saying, listen, you guys used genealogy to get to Kohberger's dad, then you connected the dots, and you got it to Kohberger. All of that is fruit from the poisonous tree. You can't use it. Judge said, sorry, it's coming in. Your thoughts on the judge's ruling to allow basically the game-changing evidence that Bryan Kohberger's DNA was on that knife sheath snap?
Yeah, game-changing is the right words for this. I mean, look, the DNA bombshell ruling means that the DNA on that knife sheath that apparently belongs to Bryan Kohberger is going to come into evidence. And that's a very, very difficult hill for the defense to climb, to try to allege that this DNA was in fact not Bryan Kohberger's, or it was there by coincidence, or there's some other reason why his DNA was on the knife sheath. So the rulings by the court, look, they're not all that controversial, to be honest with you. For the Fourth Amendment issues, we've got to have several elements that seem, at least by the court's ruling, not to have been met by the defense. But the defense has got to make every argument in this death penalty case that might somehow get them to have less evidence that is so damning as to Bryan Kohberger's presence at the scene and, in fact, possession of the weapon that was used to kill these young people. So he's got to have a right to privacy in the evidence that they are seeking to suppress. And you're right, there has to be some kind of official overreach in order for there to be a deterrent effect by the use of that suppression remedy. And so the court is saying, no, sorry, it comes in next issue. The court, again, as that gatekeeper, is saying, this is not something that is all that controversial. You haven't made the showing that he had a right to privacy in this information, and that the police and the prosecution overreached and denied him that right to privacy. It is guaranteed under the Fourth Amendment. So that evidence is coming in. And if the evidence comes in, it is very damning for Mr. Kohberger.
Another motion that the judge denied was a motion to exclude one of the surviving roommates that was interviewed several times by law enforcement over the time post-murders and told various stories to different people, according to the defense. And in this case, the judge said, okay, well, that's what cross-examination is for, and the jury will be able to decide the credibility of this witness who may or may not have been under the influence of alcohol, et cetera, et cetera. Right decision there, too? Let her testify and let the jury decide?
Again, this is the judge's purview. He's got wide discretion to determine whether the jury gets to hear this evidence, and the judge is going to be concerned about whether the evidence is credible and is there a prejudicial effect by the evidence. In other words, if it's too crazy and we put it in front of the jury, might the jury give it the wrong amount of weight? Might the jury misunderstand this kind of evidence? We see that with, for example, with doctors and experts that come in and they might have no foundation for their opinions, but jurors might wrongly think that they have some sort of heightened credibility. And so a court is going to be careful before they let in any piece of evidence in front of this jury. The defense is arguing that the credibility question is at issue because she's given multiple statements, and some of them are, at least according to the defense, inconsistent. And they're also saying that she didn't have a foundation, much like with an expert witness. They're saying if she was under the influence of alcohol or some other intoxicant or something that would affect her ability to both perceive or recall the events, then her testimony, because she was a percipient witness, is going to have so much weight with this jury. And maybe they shouldn't hear from her. Maybe they shouldn't hear from someone who might have been testifying now from things like suggestion and a memory that has been created in the time when she believes, now looking through this new lens, that Bryan Kohberger is in fact the assailant. So the court has to consider whether that testimony should be in front of the jury or whether it's just too prejudicial and the jury's going to see it and make more of it than they ought to. The judge's ruling, however, was that these are the issues for cross-examination. The cross-examination is going to go to her ability to perceive, her ability to recall, whether she was under the influence at the time that she perceived, how long did she perceive, was the lighting correct, why, at what point did you determine that it was this person who did these things? And they're going to have to go through her statements one after the other and compare them to one another. The defense, the defense has to do this in every case to undermine the story or the claim of that particular witness. I think in this case, the defense is very concerned by the fact that she's the one and only percipient witness to some parts of this event. And so they're concerned that the jury is going to give her too much credibility.
Yeah, she's got a horror story to tell, that's for sure, and all eyes will be on her when she tells it. One of the things that we learned from this filing, apparently she told one of the investigators that she believed that Kaylee Gonzalez, one of the victims killed upstairs, came down the stairs and then went back up the stairs, presumably then went up to her death. After and during this horrible scenario. Finally here, from the defense standpoint, they know they're going to lose most of this. This is all about saving a life, is it not? He's facing the death penalty if convicted. They want as much to be on the record now because this will be poured over by the appellate process because it's a death penalty. These are automatic appeals, and the more they throw out there, the more there is to, frankly, maybe get lucky on the back end because their goal is to save this man's life.
Among the defense bar, we sometimes call it trial psychosis. I'm not saying that's true here, but defense lawyers really actually don't believe that we're going to lose. I don't think by the time we get to trial, we're thinking we're definitely coming in to lose. I mean, definitely it's a possibility, but I don't even think that this defense team has been behaving as though they're coming in to lose this case. What they're talking about in these motions have merit. It's an uphill battle, that's for sure, but these things have merit. And if they had been successful on any of these, then definitely they were game changers. But the judge has been consistently ruling against them. And so they do have a difficult time with this jury. But if they lose, then certainly they are here to be saving a life, absolutely.
Okay, all right, I like that. Reframe it a little bit. They're not going in to lose. They're going in to win. That's what a good defense attorney does in any case, no matter what they're up against.